recording. There we go. Hey, well, happy Tuesday. It is October 22. It is noon and another hot topic. So today, guys, we are jumping in with I'm going to say from the title company's perspective. What are these trusts? And when they're asking for a certificate of trust, what is it that they're looking for? What are they actually asking for? So with us today from one of our wonderful title partners is Title One and Ken Taylor. So you guys give it up for Ken, and I'm turning it over to him.
Thank you, Darwin. Appreciate you guys letting me have the opportunity to come on and talk to you guys about what we require, both from a state of Michigan standpoint and an underwriting standpoint when it comes to certificates of trust and properties that are in trust. So I will just kind of hit the big important parts on them, and then as always, feel free to reach out to me, after the fact too, if you have more specific questions as well. The biggest update that we have had in the past probably 2 to 3 years from underwriters, and that's underwriters that we use and underwriters that even we don't use, it's kind of uniform across the state of Michigan, is the need for what they consider current certificates of trust for properties. Underwriting has defined current certificates of trust as a trust that is less than 2 years old. Even if nothing has changed, if it's John and Jane Smith's trust, and they got that done with their family attorney in 1997, and nothing has happened since. What our underwriting is looking for is that an attorney who's giving their impartial licensed opinion states an updated certificate that no facts have changed recently, which is why we need it within 2 years. The big thing that we need, if anything changes, if it's John and Jane Smith's trust and John passes away, even though it might have said within the original trust that Jane is able to sign afterwards, we still require an updated certificate of trust to state what the current facts are. John is deceased, Jane can now sign, and then we still send out of the trust. But it's what underwriting has really cracked down on in the past couple of years is that there's a current certificate of trust prepared for by an attorney stating the current facts of what the trusts are. If someone has recorded a trust recently, we are able to, with underwriting approval, get away sometimes with maybe an affidavit signed where they attest, hey, nothing has changed, but that's become rare. And it really, the only reason why these things do happen is claims have been filed. People have gotten kind of in trouble by maybe the wishes of the trustee have changed and it didn't get updated with a current certificate. And that's where we run into an issue. A very big second part of certificates of trust and properties that are in trust in general is, and I've had this conversation with our real estate attorney as well, is when you put a property in a trust, you have to fund that trust. Meaning, not only should you put assets into that trust, but you should open a bank account in the name of that trust. We as a title company can only issue proceeds to who holds title. And while trusts do different things in different industries, banking, your financial part of it all, for real estate, we can only issue funds back into the name of the trust. We have run into that where some parties will say, well, I'm the trustee, I own the trust, funds should go to me directly. Unfortunately, once you put a property into a trust, that trust as an entity owns that property now. You as an individual no longer own that house. You're just acting as the instrument that can act on behalf of the trust. So we're only able to issue proceeds out to how you hold title, which is most times, individually, John and Jane Doe get the money, but if it's in their trust, funds have to go to that trust. So make sure you're getting those listings, proceeds. That's how we're going to send them out. So, because we have run into that before, where someone says, well, I don't have a bank account in the name of the trust. Well, we can only issue the funds one way, and that's how you hold title. So just, that's always a good thing to bring up to your customers when you're going to a listing. Hey, it's in the trust. We'll make sure that they go and get a bank account if they don't already have one. But those are the two biggest things in the past couple of years that we have really seen come across. People not having bank accounts in the name of their trust and needing a current certificate. In speaking with we've had a lot of conversations with our real estate attorney, most trusts, when you get them now, built into when you pay for your trust documents, is you're paying for a lifetime of their attorney being able to update a certificate. Our underwriting makes their decisions based off of the state of Michigan trust statutes. So every real estate attorney should know all of them. We do have, and I can send out what the technical guidelines of a certificate are, but all attorneys do have them as to what the state of Michigan requires that they be set up like, but every attorney does have them. The biggest thing has been in the past, I'd say 4 to 5 years, really since, COVID hit, they have cracked down on how old they're allowing certificates of trust to be. And really it comes down to, they want to make sure that John and Jane Smith, who set up their trust, that they're still enforcing what they want to happen with their trust. Because we aren't attorneys. We don't know if they've changed their mind or if they decided that, John Doe couldn't act anymore, but we're going to force him to sign out. It's really to limit the risk in terms of liability where someone might not have been able or had the authority to sign anymore. Somebody changed their wishes. So that's why underwriting is really cracking down. So that's why recently we've been asking current certificates of trust. Underwriting is cracking down. They want that within a very short, under 2 years is what they've been telling us to be current on. Very good question.
Question. So then, if both people are alive, husband and wife, they have a trust in their name, they come to closing, the check will only say husband and wife trust,
However, their trust is
Okay.
titled.
and then the bank won't cash that check?
If they don't have a bank account in the name, now every bank's different. You might have, if they've banked with Bank of America for 50 years and they never got a name of the trust account in there, maybe their bank negotiates it. But all I'm able to do, because we can only issue the proceeds as to how their whole title. So if it's John and Jane Family Trust, that's how we're issuing the check.
So then what, they have to take it to their attorney?
They'd have to take it, you have to take it to the bank, maybe they have to take their trust documents to a bank to open up an account so that they're able to negotiate it.
Or
and
they
then
have to
transfer-
give it to their attorney, and the attorney will turn around and get them a check, or no?
We've seen that happen before too as well, but we're only able to cut it as to how they hold title, which is
They're both
typical,
alive.
even if they're both alive, because once they transfer that property into the trust, that trust owns the property. People will, because it is a little different in real estate, because people will say, well, it doesn't work that way with my bank. Well, we're not in the banking business, we're in real estate. And once you transfer that property into a trust, that trust owns the home. They're just acting as the,
Wait, should I tell her to make sure that you either have a trust account or you ask your bank if this is okay?
correct, yeah, yes, because we can only issue in that, yeah, but I would always say, when you're getting that listing of, hey, my property's in a trust, do you have a bank account in the name of the trust? Because that's the only way we're able to send those funds.
Here's another great question that's online, which is, can the title company prepare a certificate of trust?
We are very limited in what we are able to prepare because we are not attorneys. The state of Michigan does state that it's an attorney that is to prepare the certificate. I can tell you 100% if a trustee has passed away or if there has been a change, we are not able to prepare it.
So I've actually run into this then. Nothing's changed, but who has passed is the attorney that prepared the trust.
Yeah.
What do they do in that situation?
Any attorney is able to prepare it. We do have plenty of recommendations for attorneys that we work with who will take trust information from the party, review it, prepare a certificate for it. But yes, it's not that once the attorney's done, that trust is, you're kind of SOL. Any attorney can take that trust information, review it. then they prepare the certificate to state those current facts of the trust.
If it's not baked into the original trust document, what is an average cost, please, for an attorney to prepare a certificate of trust for them?
The question was, if there's not really built into their original cost in the trust, how much does it cost to prepare a certificate of trust? Typically, we see anywhere between, 300 to maybe 500, right in that range. It just all depends, because what an attorney is doing, especially, and we usually run into those costs when it's a new attorney that's looking at it, is, they got to take the time to review all the facts of the original trust to give their opinion on the one. But we see between the 300 and 500 is kind of an average of what we
Cover
see.
the whole thing, start to finish.
That is way more labor intensive, because usually when you're doing the trust, you're doing your entire financial planning, but yeah, probably I'd say right around 2,000, kind of right around there.
So again, the question was, what have we seen for somebody getting a trust done?
Yeah.
Um,
And that's usually from what I have heard, right in the $2,000 range. But that, usually when you're doing that trust, you're probably doing more of a wholesale estate planning. You're doing all of your items in there as well.
Especially if there's more than two people.
Correct. I did that drop reminded me of something too as well. It is very rare that trusts allow power of attorneys to be used. The reason why you build a trust document is for life estate planning purposes. It is very rare that it's written in there to allow a power of attorney to act on behalf of a trustee. I would say it's less than 2% are able to do it. We do get that question from time to time. I have a trust, they want to use a power of attorney. Well, really the proper procedure is they just need to assign, and that would be a new certificate. They need to assign a new person to be able to act on behalf of the trust. There has to be very specific verbiage built into the trust that says they allow for power of attorneys to be used. Typically, the trusts are built in for estate planning purposes, and they don't typically allow any of that as well.
so I've got another one. Holly, you might have to take yourself off, and actually ask that question directly. Because she's got can there be a trust for out-of-state property or added to a trust? Holly, you wanna maybe create the scenario you've got?
Well, let's say that there's a seller that wants to sell his property and he has property that's out of state. How would you go about, if he puts that in the trust, how would he go about doing that? Can it be added, or does it have to be in a separate trust?
The trust, it doesn't have to be property specific. When we pull the property, if they've deeded it back in there, it doesn't have to reference the property that they live in. They could have multiple properties across the country, but they don't have to be specific and put the specific property that they're selling in there. We will always attach legal descriptions and addresses to certificates of trust when we record them, because we do have to record the trust to show proper chain of title and that the parties had authority to sell. But it doesn't have to be property specific with their entire trust. So if they have properties in 5 different states, you don't have to be specific with them. What we're looking for is that it's acknowledging who are the acting trustees and that they have the powers and authority to act on behalf of the trust. But it doesn't have to be property specific.
So here's another one, which is one that I was actually thinking of. So I take a listing. I find out it's in a trust. What should I, as the listing agent, are there questions I should ask? Is there something I should be looking for?
Yeah, but my biggest top 2 things would be, again, are you able to provide me with your current certificate of trust? And if you get it, it's again, Jane and Joe Smith, and they're 98 years old. Ask for it early and often, and don't be afraid if you need pre-title done because you're not sure. I mean, we have people all the time who go, "Oh, I put the property in my trust," and sometimes maybe they didn't, or vice versa. They didn't know that they did because their attorney did before. So if you're worried about that sort of thing, order it early, but ask for a current certificate of trust. And just remind them of, hey, we have to fund the closing into the bank account in the name of the trust. Do you have that? But if you know ahead of time, if it's, you go to listing and it's Jane Doe, oh, and it was me, my husband had the trust, but John passed away. Well, do you have that attorney's information? We're gonna have to get a current certificate of trust. Those are things you can ask ahead of time just to be more prepared. But we're always able to too, and we can always look at last deeds of record and say, hey, can you let me know, are they titled in the name of the trust? Okay, if so, what's the name of the trust? Because sometimes people will too. They will move through different names of trusts, or maybe they bought and sold a bunch of property and they do a new trust every time. It does happen. So we're able to kind of look, say what the trust, what is, what the trust, who holds title in the name of the trust. But you should ask them, hey, can I see the certificate of trust? Do you have a bank account in the name of the trust? Those are two big things off the bat to get the conversation rolling.
So it's really, Lydia, thank you for your questions, because you're kind of leading into what I know my experience has been. When I ask people about a certificate of trust, you know what I get?
The booklet.
Yeah. So can you kind of
Yeah.
explain what that big old binder
So
is?
the big old binder is their trust document, and the trust could state a lot of things: end of life care plan, financial information, could have your will and testament, could have a whole bunch of items in it. Typically, when attorneys do prepare it, they will label it pretty nicely, and I'll say certificate of trust, but also it could be called declaration of trust. I've seen it a few times, or summary of trust, because that's really what a certificate of trust is. Why underwriters require a certificate, not the full trust, is one, that's a lot of costs. Well, if you're in Wayne County, a lot of cost to record a full trust. Two, we don't need all of that personal information. We just need the basic facts. Who is the trust? What's the name of the trust? Who are the trustees? Who has authority to sign? Are the powers still active? Like that. And that's what a certificate of trust is. It's usually between a 2 and 5 page summary of the entire trust document that is specific for real estate transaction. So about 2 to 5 pages is kind of the total thing, but it's 90% time called certificate of trust, about 5% times called declaration of trust, possibly, and then you sometimes get it affidavit of trust a little bit, but
And those would be the titles at the top
Correct.
of it. And that could be anywhere within that 3 or 4 inch.
correct.
binder.
Typically, I mean, most attorneys are luckily good with labeling things like that, but it should really only be between 2 and 5 pages long. It is what the average we see.
Can you just back again,
Yep.
just to remind everybody the time frame it needs? Someone missed that part. How new, current?
Oh, they're about 2 years and under. So about 2 years old is about the max that we are getting approvals on.
What are the benefits of a trust? I get this asked all the time. And because my last 2 deals had trust, both of their trusts had to be redone in order to close. So I feel like it's more complicated than good, but just let me see the light of. What's the
Yeah.
point of the
Most people do trust for estate planning purposes, and really for if it is mom and dad's house. If mom and dad both pass away and they don't have a trust, then you have to take whoever passed away last, you have to go and probate their estate. You have to go to court, you have to go through all the probate instruments to find out who can be a personal rep to sell out of the estate of whoever passed away last. Trust documents, if both parties pass away, usually they name who's going to be a successor trustee. Now, do you still have to get a document? Yes, but an updated certificate of trust, if an attorney who you're working with is good, it's maybe a day or 2. Whereas probate court could be 2 months, 3
What about
months.
versus will?
Wills are just the documents that court uses to be able to certify items. Title companies don't use wills because that's just the wishes of somebody we don't know. What a will does is it tells the court, okay, we are reviewing the wishes of the deceased. We're going to give our judgment that we agree to that, and we'll give a certified document, letters of authority, probate information. Us using wills, we don't know, because someone could have made that will in 1957, and a lot can happen between them. That's why we don't ever
How
use them.
important is a trust in today's real estate versus back when? Do you feel it's gonna have a lot more sales having trust now?
We are running into a lot more because of the age of a lot of those you know, those baby boomers who are getting out of. You see a lot of them, but it's a pretty heavy amount. I would say we do not quite a quarter, but I mean, it's a pretty heavy amount of people that we do have a lot of trust on, because they don't want to have to go through that. I don't want my kids to have to go through probate, is usually what you see. You know, we don't want the house to be left up to courts to determine these are our wishes that we put in. And that's what an attorney prepares, and why it's so important to get a current one, because they've reviewed everything, they've talked to everybody. They're putting their stamp of approval, which underwriters will approve and move
Can
on.
you guys get a list of people who get trusts and that type of stuff done? Cause another title company was at ICONnet. And he's like, oh, if you go into our website, we have access to everybody that's had these done. And then you kind of go to them and see if they want to sell or whatever the point is, like to get us leads, basically. Do you guys have a database of something like that?
We are working on we have a program coming out that we're working on. That'll probably be out in the next 2 months. That will show that we'll have access to some public record things to where you could see. But it's not complete yet. We're working on it. But the other big thing too is kind of off of that is making sure that if you do advise your customers, or if you have customers who are asking, like, should I put my property into a trust? Real estate attorneys. You know, your friend who is employment attorney isn't going to prepare the trust properly according to the Michigan standards, because that's not their field of expertise. Real estate attorneys are who you need to see to make sure to have them, make sure that they're done right. And they're the ones who also are going to know what the statutes are, what kind of the guidelines that especially underwriting has, to make sure that they're always current, and that you're not going to run into issues kind of moving forward.
So Ken, here would be a good question then based off of that. We hear the word trust and we think all of them are the same,
Correct.
but they're not all the same. Is there for us as title and for us as real estate, do we need to distinguish the difference between?
No, there's not a massive distinction. There's just, within trust, there are so many different levels of what they're used for. You just want to make sure that when you know, if someone does have a trust, do you have, you know, a certificate used for real estate purposes, is it kind of the best way to say it, because any real estate attorney will make sure to go, oh, I got to look up Michigan Land Statute 703-256, whatever the heck it's called. And there's the 9 requirements that will be able to prepare it. And they might be some different for banking and but typically within a trust, you just want to make sure, do I have a certificate available for real estate use? And they'd be able to go ahead and prepare.
So guys, if anybody ever actually says, should I do a trust? That is not a real estate person's responsibility. Matter of fact, you turn that over and suggest that they contact an attorney, because depending upon what they're trying to accomplish within a trust will determine what type of trust they may end up doing. So always when they start talking to that level, we want to recommend an attorney at that point.
Okay, I have a question. Can a trust be changeable to different person as a trustee?
Yes.
Well,
Yeah,
and
you
who make the
Repeat the
decision?
question.
The people they do the trust or what?
yeah. So asking if trust can change hands, or people can act on
Yeah.
behalf of the trust.
Instead of it's you, I could put the.
Correct, yeah, it's usually built into your initial trust. You get asked, hey, it's Jane and Joe, you know, Jane and John Smith Trust. They're gonna probably initially say, well, who is gonna act as your successor if something were to happen? You list the names,
The beneficiary.
but those can always change. You can always update that. There is no limit to the amount of times a trust can be updated. So let's say, you know, you asked Darwin to be your successor. Well, Darwin made your coffee wrong one day. Now you don't want him to be your successor. You can go get an updated one to remove him and add somebody else. There is no limit, just like a will. But that's what attorneys, that's what, you know, they're gonna meet with you. They're gonna certify, yep, you don't want it. He makes bad coffee. We're gonna get someone
Let
else.
me ask you a question. Do you recommend everyone to have a trust?
I recommend they always speak to a real estate attorney.
Well done,
So
well
What's
done.
a ladybird?
a ladybird deed is a type of quitclaim deed that puts you in title with yourself with clause that says upon my death, something happens. Either it can be, you know, I deed to myself and to, you know, my trust, but it only goes to my trust upon my death. Doesn't have to always be for trust. Typically, that's what we see. But you could be like, oh, I deed to myself and upon my death, Darwin gets my property. So Ladybird deeds, they don't take you out of title. They just put you in title with a clause that says upon my death,
Is it recorded
it's recorded.
at the time when it's done?
Most times, sometimes people might hold on to them, but because it doesn't take you out of title, most times people just go get them recorded.
Is
And
that
then-
safer than not having anything at all versus like a trust?
It's a different way to do it. You're getting to the same end, especially if you have a Ladybird deed that puts you into a trust. You're getting to the same finish
You have to
line.
Go through probate.
You wouldn't have to. That's another. It's just another failsafe, but have to go through. Not have to go through. Because we have had people say, "Oh, I thought mom and dad put this in their trust." Well, if they never deeded into it, then it didn't happen, and that trust really doesn't give you that estate planning. So it people sometimes forget it. Sometimes, you know, the attorneys will say, hey, it's your responsibility to go record this. Maybe they didn't go do it.
So does
We
the
have-
entire trust get recorded?
No, we only do the certificate because we don't want it to be, because
Not you, like when somebody makes a trust.
no, when someone makes a trust, what an attorney says, from our experience, either attorney says it's your responsibility, homeowner, go put the property in the trust, or they draft a deed and they say, we're gonna record this for you to put the property into your trust. But
Nobody sees all the trust paperwork.
no, that's why we ask for a certificate, because there's too much personal information that once recorded, then that it's just out there. You
Well,
can't
and
get it.
again, when you're listing a property and you say, do you have a current certificate of trust? They're gonna go grab, it's typically a 3 or 4 inch binder that's full of papers. Cause they don't know what a certificate of trust is. And when you say it, they're gonna bring you a binder thinking that that is the certificate of trust. And one of the things if the title company we're using is close, they could just say, hey, stop by the title company with this binder.
Yeah, we do that quite frequently. We have people who just, you know, and agents, you know, we're all not attorneys. So we just happen to see them a lot, but we have people all the time that'll stop by the office with the binder and we'll go through it. And we'll either pull it out or we'll say, one was never done. And we're always happy to be a part of the call to assist in any way that we can. Hey, maybe we call your attorney's office if you're okay. We'll ask for a current certificate. We have no problem being, you know, that extra, you know, person for you to help get that through. We're always happy to do that.
My question to you, when you said there's 2 people in trust.
Yeah.
If one of them got deceased,
Correct.
if the certificate of death is not enough, or they have to be redo the first person to change it to one person?
Yes, you still have to get the certificate.
You don't have to repeat
Oh,
that.
if the question was if there are 2 people as trust, husband and wife, or it's their trust, and one person does die, even though maybe in the trust it says that once one person dies, the other person is acting, you still have to record the death certificate and have an updated certificate to state what the current facts are. So the certificate would say husband died, wife is now acting solely as trustee. Yeah, so you have to always get it.
The recommendation for a real estate attorney is so very important, especially for the Ladybird deed. I had a recent case where there were 2 wrong words in the Ladybird deed, and it was sent to probate because the Ladybird deed was not written correctly by the attorney.
Yep.
And it caused issues that went on.
And we do have quite a bit.
Hey, guys, so just a quick, what one of the members here was just addressing is the aspect that make sure you seek an attorney with any deed, but in particular, he had a bad experience of a Ladybird deed because whoever prepared it had 2 words that were incorrect and created a great deal of hassle that it had to go through probate for him to complete the sale. So again, your recommendation of attorney, hugely important.
And we have about 2 to 3 really good ones that we work with on a regular basis too. So if you're ever in need, I mean, everyone's free to choose, but we have 2 to 3 that we work with on a regular basis that we trust and have And know our company very well too, so always get us the correct item, so we're always able to send those
So
out.
here's another one. What is less complicated for the sale of a home, a ladybird deed or a trust?
Depends on what is in the ladybird deed, because a ladybird deed, like I said, does not necessarily mean it once upon a death of somebody, it goes to a trust automatically. It could go to, you know, we have one not too long ago where it was mom's house and she filed a ladybird deed. Upon her death, it went to 5 kids. So she passed away. Well, now 5 kids are entitled. So it just went to them and we sold it that way. So it all depends on how the person with the ladybird deed wants their estate to be handled. Maybe they don't have a trust, maybe again, 5 kids, that's where they want to go to, that'll happen, but if it. You know, what a ladybird deed does though, is it's just putting something of record on the chance that something does happen, that you do avoid probate because it went to other parties, unless all those other parties happen to be deceased and then.
Yeah, and Nancy, I would just say with, Nancy put something in the chat, and I'm just gonna say, that's why we have attorneys. Now, doesn't mean you're gonna listen to all of them, but that's one experience, but everybody needs to consult an attorney that they know they can trust. And I think a key part is, it's a real estate trust, make sure a real estate attorney, an experienced one, is involved.
Correct, yeah, because we have seen, you know, you get Ford Motor Company's on staff attorney preparing it, it might not be up to what the land statute says are recordable version for a certificate, because they don't deal in the real estate portion all the time, so getting a real estate attorney is pretty big key.
I just want to make sure I have these correct. For the trust, when you're going on a listing, you're asking them a certificate of a trust within 2 years.
Yep.
A bank account in the trustee's name, and if somebody passed away, death certificate. Those 3 items.
Yeah, but I would say bank account in the name of the trust, not in the trustee's name, in the name of the trust.
And then if they have probate, you need letters of authority and death certificate. Anything else?
You might not need a death certificate, but letters of authority for sure. It does all.
Anything else for probate?
No.
Just letters of.
But again, with probate, and this is kind of getting a little off, but with probate too, once that person dies, once that person dies and it gets deeded, it'll be deeded in the estate of whoever died. We can only issue the check to the estate. I can't give the check to the personal rep. So once you start to go through that probate process, that person who's the personal rep should go open up a checking account in the estate of Jane Doe, because that's how we're going to issue
The
proceeds.
person representative in the letters of authority.
So guys, it's 12:30 and I know this guy's time is precious. Ken,
Thank you very
thank
much.
you.
Not a problem.
And I was just kind of whispering on the side. I said, we're now talking probate, which is a great segue in for me to remind you that next week we have Wanda Roberts from Linnell and Associates coming in to talk about what probate is for the real estate professional. So that one next week will be available to you for Con Ed credit. We will be starting at noon, so make sure that you're on at 11:55. And Wanda's going to be able to answer a whole lot of questions for us in regards to probate. So it's a beautiful transition over from certificate of trust. And again, the last thing I would give you is just know that not all trusts are exactly the same. There are differences and they're done for different reasons. So don't become a consultant as to what type of trust someone should have. Be aware of those differences. And you know, Nancy had put it in here, the elder care that, the attorney that she was referring to was one that deals with elder care. And that might be the reason that that person was suggesting what they were, because it's a different type of trust. So, but I'm also starting to hear that maybe we've just discovered an additional hot topic that we need to cover. So, guys, I appreciate your time today. Again, next week, probate, be early. It's good for 1 hour, and we'll run it from there. You guys all have a great one. See ya.